into the details of the broader
Mr.
effort.
Chairman, General Bondi, it's been reported that there were at one point 1,000 personnel assigned to the task of identifying and scrubbing Donald Trump's name from the Epstein Files. Were those reports accurate?
I believe his name has appeared countless times in the documents
how
that
many
have
people were
been released.
assigned?
If I could finish, I'm going to read you the stats.
I just simply asked whether or not it was true that it was 1,000 folks who were assigned that task. Were those reports accurate?
There are more than 500 attorneys and reviewers. I cannot give you an exact number.
And I wanted to ask you about that also, because this is a different question that you're getting to now. There were 500 DOJ lawyers and others assigned the task of redacting the appropriate information, including identities of the Epstein victim survivors from the Epstein files prior to their release. 500, is that correct?
If I could have finished my answer, there were more than 500 attorneys and reviewers who assisted with the. They asked a question and they don't want an answer.
That answers my question, ma'am, and I'm going to move on. I'm going to move on.
From
General Bondi, would you agree?
This is ridiculous.
The time belongs to the gentleman from Georgia.
General Bondi, would you agree that your 8 years of service as the state of Florida's Attorney General, the third largest state in the nation, served as an excellent preparation for your current role as Attorney General for the United States of America?
Not only that, I was a career prosecutor for 18 years.
And for
18 years.
And for 18 years,
He asked a question and doesn't want an answer. This is theatrics.
Well, no, for 18 years, you prosecuted serious felony cases, including drug cases, correct?
Oh, I prosecuted homicides, I prosecuted capital cases, I prosecuted domestic violence cases, I prosecuted multiple cases, and that's why I feel for all of these victims. And did you ask Merrick Garland this when you were sitting before him, sir?
Prosecute and
I answered that question earlier. I prosecuted multiple cases when I was a prosecutor.
Bottom line, you're an experienced and seasoned.
For 18 years.
Mr. Chairman, will you remind her of the rules? The time belongs to the member of the committee.
You are a seasoned
times.
and experienced prosecutor, correct?
I think we've established that.
Yes or no?
Does he want an answer or not?
I think he wants to say
I want a yes or no answer.
I think he wants to say
I want a
no.
yes or no answer, but I'll live with what you have already said. Let me ask you this question.
Clearly,
in the prosecution of you are acutely aware of how important it is to protect the identity of victims of.
I have addressed this multiple times. I think others were cutting me off when I was trying to.
Well, I just simply asked, are you aware of the fact that it's vitally important to protect the identity of as you prosecute their, the people they accuse of? Isn't that correct?
Excuse me. As we have said multiple times,
protection of the identity
of all victims
of the victims
are
is
protected.
so very
who are
important.
protected under? Do you want me to answer or do you want to interrupt?
Well, because you're not answering the question. You do a Jekyll and Hyde kind of routine around here, and I just want you to answer my questions.
What does Jekyll and Hyde mean? Can you explain that?
Well, it means you're nice to the
Explain
Republicans and you turn like Hyde on Democrats. But let me ask you this, ma'am. We have the Epstein victim survivors here today. Representative Jayapal asked a simple question: if you would be so kind and honorable as to turn around and face them and apologize to them for outing them. I mean, how many lives have been derailed because your department was either sloppy and incompetent or willfully trying to intimidate and punish these ladies for
time is
coming
up.
forward?
The time of the
Which
gentleman-
was it?
The time of the gentleman has expired. The gentleman yields back. The chair now recognizes the gentleman.
Johnson kept returning to the scale of the operation, seeking confirmation on the numbers and the purpose behind the extensive review process that had been underway. Bondi drew on her extensive professional background to explain her approach. With more than 18 years as a prosecutor in Florida, she had handled serious cases ranging from homicides to complex felonies. Her experience included work on drug-related matters, domestic violence situations, and other challenging prosecutions that gave her a strong understanding of the need to support those affected by serious crimes. She emphasized how that foundation prepared her for the demands of leading the Justice Department, where balancing public access to information with careful safeguards remains a top priority in cases like this one. The review process itself involved a tremendous amount of work from dedicated teams. More than 500 attorneys and reviewers contributed thousands of hours to examine millions of pages connected to the investigations. Their task followed guidelines set by the Epstein Files Transparency Act, aiming to release responsive materials while removing details that could identify survivors or violate legal standards. Bondi pointed out that this multi-layer approach helped ensure compliance and protected vulnerable individuals who had already endured significant hardship. Yet questions persisted about the exact scope and whether additional personnel beyond the core group participated during peak periods of activity. As the exchange continued, the atmosphere grew more intense. Johnson described what he saw as differing styles and how Bondi engaged with members on opposite sides of the aisle, using the term Jekyll and Hyde to illustrate his point. Bondi sought clarification on the meaning, and the conversation underscored the partisan undercurrents running through the hearing. Committee leadership stepped in several times to maintain order and manage speaking time, but the interruptions and pointed replies showed how charged the topic had become. Throughout it all, Bondi reaffirmed her commitment to the work her department had undertaken, highlighting the careful steps taken to meet congressional requirements without compromising essential protections. One of the most emotional parts of the session came when attention turned to the presence of Epstein victim survivors in the hearing room. Democratic members urged Bondi to address them directly and acknowledge any difficulties caused by the release process, suggesting that some personal information may have been exposed in ways that affected lives. They raised concerns about whether the efforts were thorough enough or if oversights had occurred that added to the challenges faced by those coming forward. Bondi had addressed victim safeguards multiple times earlier, stressing that the department remained focused on shielding identities as required by law and policy. The moment brought a human element to the proceedings, reminding everyone of the real people behind the documents and the importance of handling such materials responsibly. This hearing did not happen in isolation. It reflected ongoing efforts to implement the transparency law passed by Congress, which called for the release of substantial records while maintaining necessary boundaries. The Justice Department had already made millions of pages available, including various forms of evidence and communications, but the process included batches released over time, with occasional pauses for additional checks. Critics, including some lawmakers, expressed disappointment over delays and choices around what was redacted, arguing for even greater openness. Officials maintained that the work involved extensive coordination to avoid unintended harms, especially given the volume and complexity of the files accumulated over years of investigations. Rumors and discussions have continued in the months surrounding these releases, with various reports suggesting that reviews may have included special attention to certain prominent names. Some accounts mentioned instructions to flag specific references during the examination periods, though department statements describe these as part of standard procedures to ensure accuracy and legal compliance. It has been said that large teams worked under tight timelines at points, pulling in resources from different offices to meet demands. These elements have fueled speculation about influences behind the scenes, but available information points to a focus on fulfilling legal obligations while prioritizing victim privacy. Neutral observers note that separating verified details from ongoing chatter remains important as more materials potentially emerge. Bondi's responses during the hearing also touched on the broader context of her role. She spoke about the demands placed on the Justice Department when dealing with high-profile and sensitive matters that attract significant public interest. Her prosecutorial history, she explained, shaped her view that thorough processes help serve justice without causing additional harm. The committee's setting allowed her to defend the scale of the effort, noting how hundreds of professionals dedicated their expertise to the task. At the same time, the questions from Johnson and others kept returning to whether the outcomes fully aligned with expectations for complete transparency as outlined in the governing law. Beyond the specific clash, the session raised larger issues about how government institutions manage information that touches on powerful figures and those who have suffered harm. Advocates for survivors continue to call for assurances that protections are robust and that releases do not create new difficulties. On the other side, transparency supporters push for minimal barriers to access so the public can understand the full scope of past events. This balance is never easy, especially when millions of pages are involved and expectations run high on all fronts. The hearing captured these tensions in real time, with participants speaking passionately about their positions. Additional layers of the story have emerged in follow-up discussions and reports since the hearing. Some materials were temporarily removed for further review before being reposted, prompting more questions about the reasons and the timeline. Lawmakers from both parties have expressed interest in continued oversight to ensure the process moves forward effectively. There are also mentions of related inquiries into how certain records were handled during earlier phases, adding to the sense that this chapter remains active. Public interest stays strong because the underlying matters involve serious allegations and long-standing questions about influence and accountability in elite circles. As details continue to surface, many wonder about the complete set of records and what they might still reveal once all reviews conclude. Department updates have a firm commitment to the transparency goals, while acknowledging the challenges of working with vast archives that include sensitive personal elements. The presence of survivors at the hearing served as a powerful reminder that behind every document are individuals whose experiences deserve respect and care. This human dimension often gets lost in political debates, but remains central to why these issues matter so deeply to people following the developments. The reactions to the hearing spread quickly across media and online platforms, with commentators analyzing the key moments and what they might mean for future oversight. Some viewed Bondi's firm responses as a necessary defense of departmental procedures, while others saw the democratic questioning as essential accountability. Either way, the event underscored how Epstein-related files continue to generate strong opinions and calls for clarity. It also highlighted the role of congressional committees in pressing for answers on behalf